All right, as we continue the English law series into the Cestui Acts of 1540 and 1707, while I was doing the process and writing some things down, I realized I could add some more meat and more substance to give us some more depth into our knowledge of the land tenure system to which we are arrived at now in the third level of use to land, moving into the fourth. And I came up with um, backdating a bit more of history to again um, allow ourselves to see the evolution of the English law of land. Okay, so I start here. As we learn from our introduction into the statute that uses 1535 and those of King Richard III needing Parliament to witness a transfer of the legal title he held so as to be formally removed from his position held as a fiafi while he was Duke of Gloucester, and so that he can accept the throne um, entitlement of the king. Um, we seen that he had to return the legal title of possession back into what the law before recognized as the singular Cestui use. Thereby, the Cestui use became the holder of the legal title once more, yet also still held in confidence those subsequent uses attached to the equitable use he was responsible for under the Cestui use title, which were managed according to the courts of chancery. At this point, we conclude the use was still regarded as an equitable interest and not directly administered over by the common law courts. The use was purely equitable, so not yet a common law interest, and later happened during the reign of Henry VIII and the statute of uses. We have already learned, which we had already learned in previous videos, which officially made the Cestui use the holder of the legal title held in the common law through the elimination of the capacity of a fiafi, thereafter creating a new common law title in which all subsequent equitable interests were still thereafter firmly recorded for the courts of chancery to administrate over. To give more depth to the use, sorry, my throat's a little bit raspy from I was at a fire with a couple of guys drinking some beer just a couple nights ago, and it's dry here. I should put some water on top of the stove to get a little bit more humidity. So I'm a little bit raspy. Forgive me for that, but let me continue. To give more depth to the use, the constant struggle for the king to hold on to his income, and next, the barons and lords to hold on to theirs, we can return to the year AD 1290 under the reign Edward I and the statute of QUIA emptore. QUIA emptore was created to stop subinfeudation of land interest. Now, let's look at the legal definition of subinfeudation, which were states in English law. It defines the act of an inferior lord by which he carved out a part of an estate which he held of a superior and granted it to an inferior tenant beheld of himself. Unquote. Tenants of a superior lord would create smaller states. I'm just, uncovering a little bit more depth into that definition. Would create smaller states from their interest, so to next be considered lords in their own right, whereby they held a title immediately serving a superior lord, and then from this title gave a different title, a lesser estate, to another now who owed homage to the before tenant, now a lord, via holding a superior title to this new tenant. When I say lesser, it doesn't mean essentially a smaller in size of an area of land, but can be defined lesser because it's reduced to the rights granted to it, its own limitations, and those limitations were, could be upon the alienation of this new title, where it was gifted or devised or whatever, or granted. So limitations, always limitations would create smaller and smaller and smaller estates. It could be still in the same area of land, but a smaller right to those rights where they can alienate it, or granted or gifted or devise it. The issue with this action creating smaller estates, as I continue here, against the superior lord's interest is this. If the immediate tenant died, the agreement to the lesser estate was still in effect. And like development of the use, which was created to circumvent the common law title of the feudal tenure, these smaller titles, subinfeudated from the immediate tenant's equitable titles, could not be extinguished, often to the demise of the before interest owed to the superior lord. For instance, if the tenant created an estate, let's say, which he rented out for less than a shilling a year or whatever, when the tenant died, the interest of the land now was subject to this lesser estate, thereby the superior lord was now stuck with this new agreement. He lost his original agreement or his original interest, and so served to reduce the value of what the lord before had with the original tenant. In essence, the former agreement he had with the now dead tenant was in many cases distinguished according to its own limitations and agreements within the estate interest itself. Thereby the superior lord was now stuck with this lesser estate. As we begin to see that most of the evolution of the English law system was reactionary. In essence, it was a continual battle comprised of the monarchy, supreme feudal lord feudal lord over all tenures, trying to secure his income in the common law right to land against barons and lords who were working to secure more wealth for themselves by creating beneficial estates of use not recognized in the common law, who next were wrought with tenants wanting to control their interest to also become more wealthy, also a level of lordship, landlord if you please, by controlling an estate given to his tenant. As the old saying goes, all shit runs downhill and ends up taxing the poor in the end. So let's just do an overview. The connection with those interested created by the church so that lords could circumvent the common law was met in 1279 by the Statute of Mortmain to restrict this type of mortmain interest. And in tandem, so running in parallel with these type of estates, there was interest created by tenants of superior lords was met by the Statute of QUIA and Tora as to stifle the action of subinfeudation. Then, from here evolved into putting the legal title into a group of fiefs who never died, and so incidents, warships, and marriages that were recognized in a common law could be circumvented, thereby reducing the income of the king. This involved into the need for the creation of the courts of chancery to administrate and create the rules over these new equitable beneficial interests not recognized in common law, in order to simply just constantly maintain the peace of the kingdom. To then next move into the statute of uses 1535, whereby a hemorrhaging and strong-willed king, King Henry VIII, needing money instead of initiating the most unpopular introduction of another tax, he focused on the reformation of the land laws. We can plainly see that all English law is, and all it ever was, is the evolution of man just wanting the right to control an interest in land, and just more or less just wanting to will it to who his family and who his lineage was. He just wanted to be able to control that. Often, always to the demise of a superior interest held in someone else. All English law is absolutely the hierarchical system of landholding initially, whereby the legal personages are endowed with particular powers and duties, subject to the limitations of the land, estate, or property one holds, and each lessening to this is made subject to their own witness agreements annexed to the limitations that the law has evolved into over that interest consubstantiated with a particular legal personage. I repeat, that seems a little convoluted, so hopefully this will help to extinguish that sort of quagmire I just said. Maybe if I listen to it, it might make more sense. Didn't make sense when I was reading it. reading what I wrote. Especially, I repeat, especially when people make passports. Uh, or like world passports or national passports, and or documents or self-determined affidavits of sort, which claim what everybody already is. I'm a living being. To then state they have a right to this property, so acknowledging a self-defeatist argument because they do not know what that law already recognizes this, to the extent it does not commingle common law or equitable interest with those of dominion. But now the self-determiner is doing it upon himself, and as such gets thrown into the more forgiving law of equity, thereby eliminating the rights held annexed to the common law interest and before his true dominion rights. Or you get what I'm putting down here? Like I maintain, everyone is doing it to the detriment of themselves. The problem is you, not the system, but the one who has yet to use the English law system properly. Until then, you are not ever using the perfection of the law that has already been settled, and so secured in your favor. The land, namely. It's all secured through law. And by the way, as another entry of vice, okay, and you can just tell me and put it in the comments, take your advice and shove it up your whatever. I don't care. Do whatever. Okay? Stop using scripture to affect your lawful rights. Most instill or interpret scripture at a Sunday school level, which is the worldview. Okay? And then next cherry pick scripture while it's saying that the entire book is true. Well, if the entire book is true and you're waving it around, that means all scripture is 100% true. So is all in effect. So that means there's scripture to balance that scripture. My God, no wonder we are treated as wards. We are not ready to carry the law to do our own bidding. Okay? I'm 12 minutes in. Let's stop here. But hopefully, with what I just read and brought in, is you can see that everything has just been through a process. No one's doing anything to you. You're just measured against your own agreements. And immediately when you're holding those possessions and you want your rights to property, and in fact, I just brought something to someone's attention, or actually I was bringing to the attention of Facebook. Maybe I didn't bring it to Facebook. Maybe it was another one. Anyways, that even in its own charters and the own constitution, they remove property rights in Section 7 of the Charter of Rights and Freedoms. I think it's the right to life, liberty, and security of the person. It doesn't say security of the property. They're telling you you don't have it. And then you're coming into court and saying, I have my right to property, and out comes the 12 gauge, and I'm gonna secure that right. Well, there is no security in the property in the first place. It's a third level use to land, to which you're a quasi-trustee. And then you are saying, well, I'm a man as well, and I have a right to protect my property. But you just did. You just did it right there. You just eliminated your right as a man by bringing in the attribute of property. With that, I'll end this, and we'll continue on.